Good afternoon and welcome to today's session. My name is Paul Holcroft and I'm Associate Director of Operations at Croner. For those of you who don't know who Croner is a business that provides employment law, HR, health and safety support to businesses. And like a lot of people at the moment, I'm here working from home. And I thought it'd be good to get on and do a session where we can discuss what's currently going on. This is going to be a session which is open to our clients who are going to be attending this, and also open to businesses as well who want to come on, ask any questions, and we'll see if we can help in any way that we can with some really nice practical guidance that applies to your business. For us as a business, over the last few weeks, we've seen calls increase around about 350%. And the nature of those calls has been about completely new topics that we didn't have before. It's been about furlough, it's been about the job retention scheme, and it's been about the ever-changing rules that go around that. And that's what I'm going to help a little bit with today. So I thought it would be good to split today's session into three parts. Firstly, I want to go through what's the current situation, what's the current state of play, do a bit of a recap on that, and then go through quite a few FAQs that we're getting from our own clients, and thanks to the people as well. And we've had quite a few questions which have been sent over in advance of the session, which I'm going to have a chance to run through as well. Then we'll move into an open question and answer session. Feel free to ask anything you want. Just type it at the bottom of the screen. I will see it pop up and I'll move through those questions as we move through the session. And if you don't get an opportunity to get your question answered today, maybe you don't feel comfortable in asking your question today, or if you're watching this as a recording as well and you want to then ask your question, we'll get back to those questions. But if you can just send that over to us in an email address for that is covid19@cronercommunications.co.uk. Send that over to us and we'll get back to you on that. And then the third and final part that I want to go through today is a lot of businesses have gone through furlough. They've done furlough. In the first part, I'm just going to cover, have we done that right? Let's just make sure that's all in order. But a lot of businesses have done that. There are some fluctuations with more people going off now, with people maybe thinking about coming back now. But for the general side of it, a lot of that furlough work is done. But it doesn't mean that the complexities that are happening around employment law and around your business, that they're over. We're really in the eye of the storm at the moment. And some of the worst issues and most complicated things that we have to deal with are still to come. Think about people returning to work. Think about safe distancing when they come back to work. Think about redundancies, and we're getting asked a lot of questions about redundancies, and I'll help cover that off as well. So that's the third part that I'm going to go through at the end of the session. So if we just go into the first part of it and we give a bit of a recap about where we're at, okay, and let's just make sure that the furlough that we've done already is compliant and everything's been done right, because that has been a bit of an ever-changing guidance and set of legislation on what as a business we should be doing. So it was the 20th of March when the job retention scheme was announced by the government, and since that point we've had some guidance. Some guidance came out 6 days later. That's been frequently updated, the guidance telling us how that applies in practice, how employers should be doing it. And we've also had a piece of legislation, and that's called the Treasury Directive. And the Treasury Directive came into play 15th of April. Now, I'll talk to you about what these two things are. These are the two things that we're using to guide us through this new landscape. So great, we've got the job retention scheme. We got told we could claim back 80% of employees' salaries through this job retention scheme. And we know the purpose of that scheme was for the problems that we envisaged with the economy, and that we didn't just want mass redundancies to be made, okay? That's great. We had to then interpret that as how we would apply that to businesses and how we would give advice upon it. And that's where we've got the two pieces of guidance. So we've got the government guidance, okay? This is issued on the government website. It's been frequently updated, and it tells us what we should be doing as businesses in these circumstances. And I'm going to apply this to a lot of the things I'm going to be discussing today. Okay, but let's think about what that is. That's a set of guidance from the government. It's not a piece of law, it's guidance from the government, okay? So if there's ever a point where that comes into contradiction with a piece of law, the piece of law will prevail because the guidance is guidance. It's persuasive, okay? So then what we need to think about is we actually do have a piece of legislation, and that's called the Treasury Direction. Okay, so the Treasury Direction is something that came out of Section 76 of the Coronavirus Act 2020. And that is the first actual piece of legislation that we've got to take us through this. And we need to read these two things together. Some things are covered in some things are covered in others, and some things contradict each other. We need to think about how we're going to deal with that as well. But just as a general overview on that point, the Treasury direction and the government guidance, if they ever come into contact with each other and they contradict, the Treasury direction will prevail because that is a piece of law. Okay, the HMRC are bound to follow that. So let's go back and talk about a lot of the questions we were getting asked a few weeks ago, which have become much clearer as the directions come out, as more guidance has come out. Is that question is, well, what should I have done to put my employees on furlough in the first place? Now that's nice and clear, okay? 3 things that we should have done, 3 really clear grounds that we should have covered, okay? So number 1, they need to be clearly instructed by the business to stop working, okay? That's key. They need to be told to stop working. That needs to be clear. Well, what's working, okay? Working means if they are providing services or they're generating revenue for a business. So they can't be sat at home doing a few emails. They can't be sat at home just doing a bit of work for a client. It's absolute. They can't do anything. That's rule number 1. They cease working, okay? Rule number 2 is that it lasts for a minimum period of 3 weeks. So yes, you can place somebody on a period and agree with them to be furloughed, and then they come back within a few days because work changes. It just means you can't make that claim under the job retention scheme. Another thing that's been a bit of a confusion for our clients as well has been about whether or not you can place them in blocks of 3 weeks. It's not blocks of 3 weeks. It's a minimum period of 3 weeks. So it can be 4 weeks. It can be 5 weeks. That's fine. It doesn't have to be blocks, but the minimum has to be a 3-week period. And then the third thing that we need to do is we need to make sure that they're instructed to stop working due to circumstances arising out of coronavirus. Now, at first, there was a bit more of a clearer, not clearer, but a bit more of a stricter guidance on this, that it had to be in relation to an avoidance of a redundancy situation. That's gone. Okay, it doesn't have to be to do with that anymore. The 3 things that we need to cover are 1, they've been clearly told to cease working. 2, minimum period of 3 weeks. And 3, that is in relation to coronavirus. Okay, so that's how we do it in the first place. That's where it's done. But then we go through the process of how should that have been done. And when I spoke before about the Treasury direction and I spoke about the government guidance, those 2 things in this area, they do contradict each other. So the Treasury direction says that only if the employee and employer have agreed in writing, this may be electronic, maybe email, only if they've agreed in writing, which in reading that says that the employee needs to respond to say, yes, I agree. Or we have a form which says a letter which says you agree to be furloughed. They sign that form and agree to it. You've also got the government guidance, and the government guidance says that there needs to be a written record. This is a lower bar, says there needs to be a written record, but the employee does not need to provide a written response to that. So, bit of a lower bar on that. The employee doesn't need to come back to us. But those 2 things are contradictory. And as I said before, if they contradict each other, the direction's going to prevail. That's a stronger piece. Well, what's been good in this area is recently there's been a letter which has been issued out from the HMRC, and the HMRC have said that they're going to be okay if the employee doesn't respond, but it was clear that they were placed on furlough. We satisfied the 3-part test that I talked about before, and that was done with them. Think about this, and the last point, just on what we should have done with furlough, is there's 2 parts to this. One is we can't just place an employee on furlough, and they can't just request to be furloughed. There needs to be agreement between both of us, okay? Offer and acceptance. We need to agree between both of us that they agree to be placed on a period of furlough. That's number 1. But then think about the second part of it. If you're going to pay 100% wages, that's fine, because what you always need to remember with furlough, with the job retention scheme, with the Treasury direction, all other employment law is still in place. This doesn't completely supersede everything. We have to interpret this in line with previous employment law. If you're going to put an employee onto 80% of their salary, you need to agree with them that you're going to do that. If you don't do that, then that could be a breach of contract, fundamental breach of contract, maybe leading to a potential constructive unfair dismissal claim, and potentially an unlawful deduction from wages as well. I think there's a high risk of all of those areas. So what you need to make sure you do if you're doing the 80% is, yes, 1, you agree to a period of furlough, and then secondly, you agree to the 80% as well. Okay? So just let me have a look at some questions that have come in. Okay, so a question. Hi, Paul. I was wondering if someone can be on annual leave whilst they're furloughed. This is a really good question. So, in the UK, Working Time Regulations 1998 covers this area. An employee gets 5.6 weeks of annual leave. They get 4 of those weeks under EU Working Time Directives, and then they get another 1.6 weeks, which are our bank holidays. So, as I said before, normal employment law applies. They're entitled to the 5.6 weeks a year. Now, there's been, in the guidance, it said that an employee can roll over annual leave into 2 following years if it's not reasonably practical for them to take it within that leave year as well. That's another point to consider. But in simple answer to your question, yes, someone can be on annual leave while they're on furlough. Because as it stands now, and this isn't clear in the guidance, this isn't clear in the directive, but as it stands now, normal employment law rules apply, and in those normal employment law rules, people can take annual leave. So we're fine with people to take annual leave. I think the question that we're getting asked quite a bit as well is, can an employee be forced to take a period of annual leave by their employer? So as we know currently, under Working Time Regulations, we can ask an employee to take a period of annual leave, as long as we give them double the notice required to take the leave. So if you want one of your employees to take a week off work, you would give them 2 weeks notice that you're going to ask them to take 1 week off work, if that makes sense. And that's what we've always been entitled to do. And as it stands currently, nothing's changing that. So yes, people on furlough can be asked to take a period of leave. And yes, in theory, we can force that leave upon them. What you need to think about here is, what rate of pay are you going to pay this annual leave at? Because you wouldn't be paying this rate of annual leave at 80% pay. We would say the safe thing to do in these circumstances would be to pay any annual leave that your employees take over this furlough period at 100% pay. That would be the advice that we give. Okay. Okay, so we've got a question here from James. Hi, Paul, can I furlough employees on sick leave? I've jumped to this question because this is a question which we are getting asked quite a lot at the moment. This is a question that a lot of our clients are asking us. This has been clarified in the guidance, been clarified in the directives as we've gone along. But again, this is another area that contradicts. And I'll talk to you about how the guidance contradicts the direction on this one as well. So the Treasury direction covers this to say that an employee can be moved from a period of SSP, sickness absence. They can be moved from that period onto a period of furlough, if agreed by the employer, the other way I talked about before. They can be moved onto that period, but only once the original period of SSP ends. So think about how that works, that you've got an employee who's on a current period of sick leave, SSPs covering that, and that SSP isn't due to end for another 3 weeks. That under the Treasury direction, we have to wait for the end of that 3 week before we can place them onto a period of furlough. But the guidance doesn't go as far as to say that. The guidance says essentially you can cut short the period of statutory sick pay that they're on and move them, agree them to move them onto a period of furlough. And that says that that can be done for business reasons. Pretty wide, pretty far-reaching, that I think we're okay there to move people over from statutory sick pay and move them over to furlough. They get 80% pay, which is going to be better for the employee. Now, you've just got to make sure that as well, just to be clear on that, you can't claim for the statutory sick pay and furlough under the job retention scheme at the same time. But what we need to think about with that is that you do again have contradictory guidance, and what do we do with that as a business? And it's difficult, and I think this is one of the areas that is going to be clarified, because if we're reading the Treasury direction, the stronger instrument in this, if we're reading that, then that says we need to wait for the period of SSP to end before we can move them onto a period of furlough. And the government guidance is saying, no, feel free to move them over to furlough while they're on a period of SSP. What we would say is best practice advice, safest advice for a business is to follow the Treasury direction. They wait for the period of sickness absence, the period of SSP to end, and then move them over. You can follow the government directive on this. You can follow the government guidance on this. And a lot of our clients are doing that as well. But our advice on that is just go into that knowing what you're going into. That if you go into it and you do move them over from a period of SSP onto a period of furlough without waiting for that period of SSP to end, and exactly in contradiction of what the direction says, but following the guidance, you might be able to claim that back. You might be able to claim that back, but also you might not be able to claim that back. So just know that if you're going in and you're paying that, that's the risk that you're taking when you do that. Okay. Okay, I've got a question here from Station Garage. What if you ask someone to come back to work and they refuse? Where do you stand? This is a great question. This is a question that we're getting asked more and more. And when I come on to the third bit, we'll talk about how things are changing and getting people back to work. This helps. I'll cover this now, though. So what if you ask someone to come back to work and they refuse? Where do you stand? So what we're seeing with quite a lot of our own clients at the moment is that things are looking better for them. They're starting to get more orders in. They're starting to bring people back to work. Yes, we've got the job retention scheme up until the end of June. We can use that up until the end of June as businesses. But some businesses are wanting to get people back to work, and they've got a big chunk of their workforce on furlough, which means that they can't then fulfill the new contracts that they're getting, all this new great stuff that's happening for them. What can we do with those employees? What's the situation? And I was giving advice to a client yesterday where they were doing exactly the same thing, where they wanted somebody to come back to work and the employee refused. The employee said, no, I don't feel safe coming back to work yet. I don't feel like we're over the worst of this. And I personally don't feel safe coming back into the office. What position is a business in that circumstance? It's a new situation for us. The first thing that I'd always be thinking about when you want someone to come back to work and where do you stand is, first of all, I'll be thinking about shielding. So shielding was a term that we had, and this will be happening within quite a few of your businesses. Before the whole furlough period started and all of that, you had employees who were shielding quite early on. So an employee who is shielding is not necessarily themselves sick, but they're someone who is clinically, they're extremely vulnerable. They will care for someone who's vulnerable, or they will live with someone who's vulnerable. That's what gets them into that category. Now, they should usually have a letter from their GP to say that they're shielding. It should talk about the period of time that they're doing that for as well. And that's what we think about when we're looking at an employee who is shielding. I spoke before about sickness absence, so I can talk about that when it comes to shielding as well. But an employee who's shielding, that's what we need to look at first. What classification are they? So if the employee is shielding, that's why they can't come back to work, because they themselves fall into one of those categories. They care for someone, or they live with someone who's in one of those categories. Then they're designated as shielding. And an employee who is shielding only receives statutory sick pay for that period, because this is a new term for us. It's not sickness absence as it would be under your current contract. All this obviously depends on what the contract says, but that employee we would designate likely as shielding, and they would get paid statutory sick pay for that period of time. But what if the employee doesn't fall into one of the categories of shielding? What if they're not a vulnerable employee, they don't live with someone who's that, or they don't care for someone who is in that category? What's our options then as a business? Well, the options we've got then are to say to that employee, well, normal employment rules still apply to this situation. Under the normal contract of employment, and this is as long as you're satisfied that you've covered all the social distancing rules, that your health and safety's up to scratch, and that everything that you're doing, you're satisfied that if they do come back to work, they're going to be safe, then we can say to them, we've got work available for you. We want you to come and fulfill that work for us. Well, what position does that leave us in as a business? If they're not ill, they're not on a period of sickness absence. So strictly speaking, we have work available to them. We're giving them a reasonable management instruction to attend work. Dependent on what your contract of employment, your handbook says, that this could be dealt with under the disciplinary procedure to say that this was a conduct issue. We'd requested something of them that was reasonable and they've gone in contravention of that. And we can invoke the disciplinary rules to deal with that employee and discipline them. The other option you'd have as well is you could agree a period of unpaid leave with the employee. This is by agreement as well. We wouldn't just be putting them on a period of unpaid leave unless it gives you the right to do so under your contract for that. But what we would be doing is saying to the employee, can we agree to go on a period of unpaid leave? And the other option you've got is to leave them on furlough. You can agree to leave them on furlough for a period of time. But I'm just thinking that is not an option that a lot of our clients want to take, because they're worried that a lot of their employees are going to stay on furlough and prefer to be on that, when they need to get back to work and need to be working. I'll just caveat the advice that I gave a minute ago about disciplinary processes. So with disciplinaries, yes, strictly speaking, we're applying the employment law rules that we had before, but just think about this, about how reasonable that is with the workforce as well. That yes, there will be some employees who we think might be mischievously not wanting to come into work for whatever reason, but more than that, there'll be the employees who are genuinely worried about their health and genuinely scared about coming back in with the situation that everything is at the moment. I think it's reasonable to take that into account as well. And I think that if we were looking at anything that came out of this and a claim that came out of this, it would be reasonable to take that into account as well when considering whether to go down any type of disciplinary process. Okay, I hope that helps. I've got another question here. Hi, this is from Nicola Bellion. Hi, can I communicate with my staff while they are furloughed to keep them updated on the business? Okay, so this is a question we're getting a lot of. What can you do with your employees when they're at home? They're furloughed, so can we do anything with them? Can they do anything? Can we communicate with them? What does that do? Does that jeopardize our ability to make a claim under the job retention scheme? So what you need to think of first of all is you need to think about what the definition of work is. So work, anything that provides service or generates revenue. I went through that before, okay? That if you're communicating with them and keeping them updated on the business, personally, my advice is that's very good business practice and something which I think all employers should be doing. I think everybody should be updating their workforce on what's happening, letting them know what's happening with the job retention scheme, what's happening with your business, what's happening with furlough, what you're thinking about the period of time that that's going to be happening for. I think it's perfectly fine to communicate with your staff. I think it's perfectly fine to keep them updated on the business and let them know what's happening. And that's what we're advising a lot of our clients to do as well. Keep that communication up. This isn't all about how you were going to fall within employment law. A lot of this is about how you should be handling your business and how you should be working with your employees, because the thing's going to be when we get back, and hopefully we're going to be busier than ever, we're going to need everybody there swimming in the same direction and keeping them updated, keeping them feeling like a part of that business, especially if you furloughed a part of your workforce and not the other part. Keep the communication up with the people who are off and make sure they're engaged and make sure they know what's going on with the business. But just make sure that none of that ever creeps into them. Can you just pick this up for me? And can you just give this client a call for me? They can't do that. They can't undertake any work. But yeah, fine to keep up the communication with them. Okay, I've got another question here from Joe Bates. I have a vulnerable employee who is advised by their GP to shield for 12 weeks. Can I put them on furlough? This is a good question. I covered sickness pay before. I talked about shielding a little bit. For me, this is a question which highlights how people have been asked to shield by their GP. If you follow the Treasury Directions guidance on this, and I'll just go back to what that was, Treasury Directions guidance says that if someone's off on a period of sickness absence, you need to wait for that period of sickness absence to end before you can place them onto furlough, okay? Government guidance saying you can just move them from sickness absence to furlough for business reasons, and I talked about how those two clash and which one the most powerful one is. If you follow the Treasury Direction on this, then this is quite harsh on employees who are shielding. I think this was probably an unintended consequence when this was drafted. If you've got an employee who's been told a few weeks ago, I don't know how far they are into these 12 weeks, Joe, but say if they're 2 weeks into the 12-week period that they've been told to shield, then you have to wait another 10 weeks of them receiving statutory sick pay for them to be able to move over to a period where they can get back to their 80% pay. So the current rate of statutory sick pay, £95.85, that's what they receive. And if they were moved back over to their 80% pay, obviously that'd be better for them. And that's why I think that this is something which, on the reading of the Treasury Direction, really picks out the people who are shielding for a long period of time, who aren't necessarily ill. So in answer to your question, as I said before, yes, you can put them on furlough. Feel free to put them on furlough, go through the rules, agree with them to go on furlough, agree with them to go into 80% pay as well. But be cautious with this, because the direction says that you can't do this until the SSP period ends. So be cautious of this. but the government guidance says you can do it for business reasons. So if you do this, Joe, then you're giving yourself a bit of a risk for your business, that if the HMRC say, no, we're following the Treasury direction, and this means we're going to wait until people got to the end of the period of SSP before we will place them onto furlough, you might not be able to claim anything back under the job retention scheme for these employees. That's the risk that you've got in that situation. Okay, so I've got Korosh Mardani has put a question in here. Hi, Paul. 2 of my employees joined at the beginning of March, but they do not have NI numbers yet. Will I be able to put them on furlough? Okay, this is a really good question. This is a question that we're getting asked a lot at the moment. This is something that I think, again, same as I talked about with SSP, the government, and rightly so, the HMRC, have got to protect their position when it comes to the job retention scheme being abused. They've got to protect themselves from fraudulent claims. It can't be that they just brought in a load of new employees into a business to put them under the job retention scheme and make a claim for their wages under that. So what they did was they said that there's a cut-off point for this. So, okay, great, that they joined at the beginning of March, but they don't have an NI number yet. The issue that you've got is that the employees needed to be employed as of the 28th of February. That was the date they needed to be employed by. But then we needed to have submitted real-time information notifying payment, which is made to the HMRC. That was by the 19th of March. So those 2 things need to be satisfied there. Real-time information that is paid by the 19th of March to be able to make that claim. So if you've got employees who've started after that date, then unfortunately no claim can be made under the job retention scheme for that. Okay, we've got another question here off Joe Bates. Can I ask one of my employees to pop into work and do 1 or 2 hours work if they are furloughed? Short answer to that is no, you can't. While employees are on furlough, they can't undertake any work for a business, provide services, generates revenue that I spoke about before. And even if it's 1 or 2 hours work in a week, no, that's 1 or 2 hours too many under the rules. They can't do a bit of work, they can't do 1 day's work, they can't do limited duties. If they're furloughed, they're furloughed. They've stopped working, and they're doing that for a minimum period of 3 weeks. If you get them to come in and undertake bits of work, you're then going to have to go back off furlough periods, back onto other furlough periods. It becomes quite messy. Maybe it's one to think about whether or not the work that they're doing could be left for now, or whether or not someone else could do it who isn't furloughed and go in and pick that up from. That'd be a practical way of dealing with that. But the simple answer is that no, if an employee is furloughed, they cease work. Okay, I'm just looking at these questions. Okay, and another question here. We had an employee who left at the end of March to start a new job. This didn't happen, and now they've asked me to re-employ and furlough them. Do I have to do this? We're seeing quite a bit of this. This is a question we're getting asked quite a lot. That we've had businesses where you had people, as you do in a business, where people are leaving you, they move on to somewhere else, they have a notice period, and also they go to start that new job, and the new job, now for the reasons that I just spoke about, can't furlough them because they're starting too late. They haven't got any work for them, they can't place them on furlough. They're either deferring the start date, they're rescinding the offer. That's something to deal with their new employer. But what they're doing is they're coming back to their previous employer, a lot of times to our client, a lot of times it's being asked here. And they're coming back to their previous employer and they're saying, can you now re-employ me? Can you give me my job back? And can you place me on a period of furlough? Now, the answer to that is yes. Yes, you can do that. You do have the option to do that. As long as the employee was employed with you on the relevant dates that I spoke about before, so going back to saying they were employed the 28th of Feb, that we were on the real-time information before them, and they've had a period where they've been somewhere else and they want to come back and be furloughed, then yes, you can agree for them to come back. Yes, you can agree for them to go on a period of furlough, and again, agree the 80% payment with them. Another question we've been asked to do with that as well is, how does that affect length of service? Does that constitute a break in service? And our advice on that is yes, that does constitute a break in the employment service with the time that they've spent away. One of the things that I would ask to consider, while yes, in principle you can do that, is, does a business want to do that? And that's another thing that a lot of our clients are asking us about, and a lot of the feeling they have is, and what's really in it for them, to bring an employee back, to pay them 80% of the pay, which you were a conduit for, you're a vessel for through the HMRC, you pay them that money, you recover it back through the job retention scheme. Is that something they want to do? And that's something that we're talking to our clients about, and a lot of them are advising that they don't want to do that, because what's really in it for them apart from helping the employee? And a lot of them are doing the opposite. They want to help the employee, they want to bring them back, and then get them set up so they can claim under that scheme and then move to their new job after that period of time's ended as well. Okay, I've got a question here from Kathy Cracknell. Hi, Katie, sorry. Hi, Katie. So apologies if this has already been asked. Can employees on furlough attend team meetings with other employees who are not on furlough? Okay, good question. This is about the definition of work. And I'm glad we're getting asked a few different questions about this and a few different circumstances as well. The question of this is whether they are providing services on this, whether they're generating revenue on this. I would say that them coming into team meetings isn't generating revenue, unless part of the team meetings is there's prospects in the meeting as well. I'd say that's likely to not be generating revenue. Question is are they providing services? Now, in the absence of a very clear definition of what this services is, I would say that the thought would be that it would involve interaction with a client for them to provide services to that client, or something which is enriching the business. They can't be at home working on things for you and creating things for you in a business. That's in essence providing services. They're providing something for you. The other thing is, though, that you need to think about is the thing that they are allowed to do is training. Now, training is made very clear that training is fine. Employees can be on furlough and employees can train. It's got to relate to their job, but they can train while on furlough. And it could be that them coming into team meetings, I assume that the team meetings are by video conference as well. There's not interaction or travel involved with that. And that could be seen to be training. What you need to think about with training is, though, that training needs to be paid national minimum wage as well. That's the only thing that we need to think about. That if it goes below national minimum wage, we always need to think that needs to be paid at national minimum wage as well. Okay, I've got a question here from Mark. Can I change employee status from furloughed to laid off? Less work for the time being and may not need them. Second question, if employee received letter from the government to stay at home, can I assume it was to shield? What exactly will the letter say and from whom? Okay, so I'll deal with the first part of that question first, Mark, if that's okay. So can I change employee status from furlough to laid off? Yes, you can. As I said before, normal rules of employment law apply. This does not supersede everything. It doesn't stop us being able to go through layoff. It doesn't stop us being able to go through redundancy. Yes, so if you've got some work and you want to bring them back, but then you want to put them on a period of layoff as well, period of short time working. Obviously that's dependent on what's contained within your contracts of employment, what's been agreed to by the employees in terms of a layoff clause. Not to get into the specifics of that. But in principle, yes. And the second question is, if an employee received a letter from the government to stay at home, can I assume it was to shield? So if they've got a letter which should be from their GP to say that they're vulnerable, they fall within that category, or they care for someone, or they live with someone who's vulnerable, then yes, they should have that. And that's something that we would look at when they're shielding. That's something that they should usually have when they're shielding. Okay, I've got another question here from Hannah. Does the employee have to agree to be furloughed? Easy, yes. Yes, the employee has to agree to be furloughed. At first, this was something that was unclear. When the job retention scheme first got announced, it was unclear about whether or not this had to be an agreement with the employee or not, or whether you could just designate an employee as furlough. But that's made clear now. Yes, you have to agree with the employee, but also remember, agree the furlough with them. But if you're going to pay 80% pay, agree for them to take 80% pay for the furlough period as well. You need to get those two things in place. Otherwise, you've got a risk of a breach of contract and lawful deduction from wages claim as well. Okay. Okay, Ed. This was like a really interesting question, Ed. So I have two staff members who are desperate to return voluntarily. They're bored and they want to tidy the factory. So I'm guessing that you're asking, do you have to let them back? Can you let them back? So I think this is something as well, and taking apart the employment law side of it and the management part of my role that I have as well. This is something that we need to be thinking about and communicating with people while they're at home. Yes, we can look at the employment rights of it, but this is a completely unique situation for people being at home, and me included with that. I've never worked from home in a role before. So it's a unique situation for a lot of people, and I appreciate how people are on furlough, people are getting bored on that as well. I appreciate that. But there's no way they can voluntarily return. So the situation that you've got is to go on a period of furlough needs to be agreed between both parties. So they agree to be on a period of furlough at the moment. Now, if an employee changes their mind, they say, you know what, Ed, I've changed my mind and I want to rescind that agreement. I no longer agree to be furloughed. The furlough period comes to an end because the agreement's gone between the parties. There needs to be an agreement on that furlough process. And then what situation are we in? Well, you might be in the situation where you don't, at that point, want them back at work. The situation we would have been in before the job retention scheme. Think of it like that, really. You don't want them in work because you don't have the work for them. If you don't have the work for them, what situation are you in? Well, you can lay them off, put them on short-time working. You can consider redundancies. That's what you would do in a normal circumstance where there was no work. But if they want to come in voluntarily, they're bored, they want to tidy the factory. If you didn't have work for them to come in and do that, they would be off furlough. But for them to come in and essentially, I'd say that is providing services. I would say that falls within the definition of providing services. That if they're coming in and working at the factory, even though they're terming it as voluntarily, I would say that would have a high risk of you not being able to claim for furlough, for payments under the job retention scheme. Sorry, for that, as that'd be classified as work. Okay. Another question I've got here. What happens if one of my staff members has two jobs? Can they apply furlough on both jobs? Yes, they can. They can be furloughed from one as well and not the other. While people are furloughed as well, they can undertake work for another business as well. They can volunteer as well. So, yeah. Okay, I've got another question here. This is a good one, something we've not gone through yet as well. So, hi Paul, I've got an employee on maternity leave for 12 months who now wants to return after 6 months and be put on furlough. Can I do that? Thanks. So this is a really good question. And this is something that we're getting asked now quite a lot. Same as people from sickness absence moving on to furlough. We've also had the question of, can people on maternity leave move on to furlough as well? So the simple answer to the question is yes. Yes is the simple answer, and I'll elaborate on that now. So how it works under normal maternity rules is we've got someone who can take up to 12 months of maternity leave, and they move through that on. You may have statutory maternity pay, you may have company maternity pay, which is higher than that. But let's take for this example, we're on statutory maternity pay. Okay, so someone on statutory maternity pay, if at that period we're receiving £151.20 per week, and they then think, okay, great, I could be getting 80% of my salary though if I was furloughed. That's much more than that. And they want to come back to work. So simply, we can agree that with them. We can agree for the period of maternity leave to end. We then go into an agreement with them that they're going to be furloughed. We then go into another agreement with them. We're going to move them on to the 80% salary, unless you're going to pay the 100% salary, Jane. But that's the agreements that you need to get with them. So sounds great for them. They move back over, they're on to 80%. Brilliant. The risk with that comes in, though, is that you can't start a period of maternity leave again. You can't pause a period of maternity leave and go back on it. They can't come back to work and then go back off again. So if you've got this employee who was always intending to take 12 months to be with their new child, to be with their family at that time, they come back after 6 months, and maybe in 1 month, you're thinking, well, I think we've got enough work now. I want people back to work. They can't go back on maternity leave. If at the end of June, when the current job retention scheme, it may end at the end of June, it may get extended, but if it ends at the end of June, well then they're going to have to, they can't go back on maternity leave, they can't be on furlough. They're in a position where they have to think about coming back to work then as well. So that's the risk of it. That's the risk of it as well, that they can't go on some of the period. But in theory, yes, you can do that. Another question here from Cynthia. How much notice do you need to give a furloughed member of staff to return to work? There's no guidance on how much notice needs to be given for them to return to work. My answer to that would be, in the absence of the guidance, that there isn't a prerequisite of any notice that you need to give them to return to work. That you can say to them that they're going to be at home. It's not like they're going to be away. I think that the reasonable notice that I would give to somebody in that situation would be that I'd want to see them in work the following day. If I wanted to bring somebody back from furlough, and we've advised some clients on that basis as well. Okay, I've got a question here from Lawrence Grigg. And I said at the beginning I'd go through a bit of an overview about where furlough was at. Then we'd move to a bit of a Q&A session, which we've done now. And then I said I'd go on to what's going to happen next. And in the what's going to happen next bit, we've had some questions submitted already, which I can go through. But the what's going to happen next bit, Lawrence, is really well covered in the question that you're asking. That's one of the key topics in what is going to happen next for businesses. So I think if I just move it on and we kind of look at a few more questions to do with that. There's been a lot of questions today. And just remember that I've got another session next week as well, at midday next week on Wednesday. So we can go through that as well. But let's talk about, this is the key thing for employers now. This is complicated stuff. You can see that from the questions that have come up, from the nuances that are coming up from within businesses. The guidance seems pretty explanatory with the direction, but when we talk about actual businesses and actual questions that's going on, there's a lot of things here which are not as clear as they first seem when you ask about them. Question we had before about training and attending meetings and things like that, not as straightforward as they first seem, and not clear in exactly what's going to happen. But you wouldn't expect all of those subtleties to be addressed, and that's why we need to interpret this. But let's think about, as businesses, what's going to happen next. So what's going to happen next is, Lawrence, you're right, people are thinking about redundancies. The job retention scheme for a lot of businesses was not a scheme that they used to avoid redundancy. It was a scheme that was used on a pause for redundancy, and they're looking to make those redundancies when the job retention scheme's over and people would have been looking back to come back to work, because there has been a diminution in those businesses and the requirements to provide services. There might not be when they come back, though. They might not be expecting, but there might be a big jump up again. And that's what we're hoping for. There might be a big jump up again, and that would be fantastic, because then we're not going to be in a position where we need to make redundancies. But the thing that we need to be thinking about as businesses now is we need to be thinking about employees coming back from furlough, what the complications with that are, what the social distancing, the safe distancing guidelines are, to make sure we've got that right in all of our workplaces. I don't think it's going to be the position where everyone just went away and everyone's just going to come back. I think what's going to happen is people are going to come back in bits. You're going to have some home working, you're going to have some people in the office. People are going to have to be spread around on desks. We're going to have to think completely differently as people who run businesses about exactly how we run that day-to-day operation of our staff. That's going to be completely different. We need to think about that when we come back and how we can fulfill our own clients and work like that. Another thing you've got to be thinking about is employees refusing to return to work. I think we've covered that quite well. Further sickness absence, is there going to be a further bout of this later in the year? Let's hope there's not. That's a possibility and one that we all need to consider, though, as business owners. And the other thing is, what about home working requests, flexible working requests, different day requests, because people have now been at home? Are they going to want to make more requests? And I think we're going to see an increase in our clients and in businesses about people saying, I want to work more flexibly. I've got evidence now. This works really well at home. I want to put that question to you now and see if that's something that you'd be acceptable with, and me working from home and changing the way we do this as a business. So let's look first at Lawrence's question. Really good question, Lawrence. If you have to make someone redundant during furlough, do they have to be removed from furlough for their notice period? So let's ask the first question. Can you make an employee redundant while they're on furlough? Yes, you can. Normal rules apply, normal employment law rules apply. There's nothing in the guidance or the Treasury direction yet which says that you can't make an employee redundant. There's nothing that says you can't do that. I'm not saying that's not going to come, but it's not in there as we're advising at the moment. So yes, at the moment, yes, you can make employees redundant. You would go through a normal redundancy consultation process. So we'd be looking at something like maybe 3 weeks we would see as reasonable. Maybe 2 weeks given the circumstances, at least doing 3 meetings with them. But if you've got anything that you're thinking about that's collective, so think about if you've got over 20 employees. If you're doing over 20 employees, you need to do 30 days consultation as a minimum. If you're doing over 100 employees, you need to do 45 days consultation. So they're the things that you need to be thinking about as well. I'm sure talking about a smaller number here as well. But if you go through a proper redundancy consultation process, which is the process that's set out in your handbook, set out in your policies, you go through that process and you make employees redundant, then the question you're asking is, can you claim for their notice period while they're still on furlough, or do they move to something else? So this is a really good question. So employees made redundant, and let's just think about, there's a couple of bits I'm going to give to this answer. So let's just think about what's in their contract of employment when it comes to notice period. You've got statutory notice, which is 1 week for every year. And then you've got contractual notice, which might be greater than statutory notice. And that's important. And I'm going to discuss that in a minute. So, for example, you've got someone who's got 2 years service. They've got 2 weeks notice. But the contract might say they've got 3 months notice, because you like to give a bigger notice for that job. You like to protect yourself, or that was what you offered for the employees when they started employment. Okay? So if you've got an employee, they've been made redundant, and you've gone through that process, you've done that. I remind, all normal rules apply, the fairness, the reasonableness of that decision. Always bear in mind they've got the right to claim unfair dismissal for redundancy as well. But you go through that process and you get to the end of it and you make them redundant. You've got a couple of options of what you do. One, you can pay them in lieu of notice. That's what a lot of employers do. They take that option. So they don't work for you for that period. That's their last day. They go and you pay them in lieu. And you pay them for the period that they would have got for their notice period. 3 months notice, you pay them 3 months, and they get that in one payment. They get paid it in lieu. My advice on that would be, if you do pay somebody in lieu, no, you would not be able to claim that back under the job retention scheme, because you don't know what they're going to be doing for that period. You can't pay in period of anticipation. I don't think they satisfy the test in that period. You then got the question of, well, if you have an employee and you don't pay them in lieu of notice, you just pay their notice period. The point I spoke about before, you might have, say they've got 2 years service and they've got 2 weeks notice. Can you just pay them that 2 weeks notice and they stay on furlough? Yes, you can. Yes, they stay on a period of furlough. So what you need to think about, though, is, and our advice on this isn't clear in the guidance or in the direction yet, but our advice on this is that yes, you can, but the safe thing to do, and the thing that we would always advise to do, especially on statutory payments, I'll come to company, to contractual, but if they're on statutory notice, so 2 years, 2 weeks, pay them 100% pay, and you claim back 80% pay of that through the job retention scheme. Okay. You've then got the second question of what if they have got contractual notice pay, and that contractual notice pay is greater than statutory notice pay by a minimum of at least a week. That's relevant because that's how we interpret sick pay and how you get paid sick pay and notice pay as well. It's a relevant term for us as well. So if they've got contractual notice which is greater, so the example before, they've got 2 years service, so the statutory notice would be 2 weeks, but you give them a month because you have greater than statutory notice in your contract, you give them a month, then would that month be paid at 100% pay, or would it be paid at 80% pay? Yes, they can still say on furlough. Yes, you can still reclaim 80% of that payment, but what do you pay them? Now, this one is an answer which is not clear. Of course, what I would advise and what the safest thing to do would be to pay them 100% pay, but there may be further guidance which comes out later to say that because the company, the contractual notice is greater than the statutory notice, you might be okay to pay them the 80% pay and recover the 80% pay, but that's a risk I would advise against doing that. So yes, in simple terms, yes, you can make people redundant while they're on furlough. A lot of our clients are considering that as well for the same reason that you asked, that Lawrence, that you've got the ability to make a claim back for 80% of that payment. Remember that the good practice and what we would be advising to do is that you're paying them 100% of their notice pay. So not what it was under furlough, what it was before furlough, what their payments were before furlough. Okay, I'm just looking at a couple of these here. And I think someone sent over some really good questions yesterday. Chris sent over some really good questions yesterday. And Chris, I think I've seen you on here. I think I've seen, a couple of your questions pop up. I've not been purposely ignoring you. I had your questions here that I thought would be really good, and I thought you asked some really interesting questions as well. One of these questions that you had, let me just look through what we've done here, because a couple of these we've covered off. One of them was a really good question, really good. Will special consideration be given to to employers who've made redundancies at this time? And this is a bit of a follow-on from the question I just answered for Lawrence as well. So, will the government look at this? Sorry, more importantly, let me rephrase that. Will the tribunals look at this if a tribunal claim was ever issued? And would the tribunals say that, you know what, in the circumstances, we're going to give you a bit of a fairer ride at this. We're going to treat you a bit more leniently because this is a really difficult time. We're going to be a bit more lenient about this. And we're not going to look as strictly at an unfair dismissal claim for redundancy payments as well. We're not going to look at that strictly as we would have done before. The answer to that, in simple terms, is no, not as it stands. There may be something that comes out which says we're going to cut some red tape, we're going to remove the element of some employees to issue certain claims. I'm not anticipating that is going to happen though, and nothing has come out to that extent at the moment. But to the flip side of that, you do have something to think about on this, and this goes a bit towards your question as well, Lawrence, which was about redundancies. And what you've always got to think about in those redundancy situations is reasonableness. This needs to be reasonable. Yes, you need to qualify it as a redundancy situation, but also that the dismissal is reasonable. Was there a suitable alternative to redundancy at the time you made those redundancies? That's the question they always ask. Was there a suitable alternative to redundancy? And in this circumstance, I think that the courts may look and say, yes, there was a suitable alternative to redundancy. That was furlough. Furlough was a suitable alternative to redundancy at the time, and that's why it was brought in. So this is a new time. There's no cases which have been tried on that basis or raising that question, but always think of that in the back of your mind, that that's something which is reasonable, something which I would always be considering when I was going through that process as well, or advising a client through that process. That might be a test that they apply. Was a suitable alternative to redundancy something new? Furlough. Okay. Another question that you asked, which was really good, was if businesses pick up in a few months, what issues could you face after making people redundant? That flows straight into the answer that I just gave. That is that reasonable? If you know that at the end of this job retention scheme period, and it may be extended. We've got 4 months. It might be extended to 5 to 6 months. We don't know yet. But if we're still in a period of lockdown, I would think it only logical that the scheme would be symbiotic. It would run at exactly the same time as the period that we're in lockdown. That's why it was brought in the first place. So if by the time the lockdown ends, the scheme's still in place, and then you think, great, business has picked up, I want to go and employ a load of people again. I want to go and employ people I had before because work's gone up, demand's gone up, the economy's really getting going again. Is that something that you can do? Well, of course, yes, you can go out and recruit. Yes, you can go out and get people. You might have the personnel issue, that the skill base that you had, you'd lost, and it takes you a lot of time to get that back within your business. That could be something that you've lost. But yes, as a business, you can go and do that. But just think back to the point that I made before, and asking that question leads into the answer that I made before, is it reasonable to do that? Is it reasonable if you've had a situation where you could have just left them on furlough, and after that work's got back up, and then you actually want people as evidence you've been recruiting after that period? Would that then go back and someone having a look at that redundancy situation, it was tested at a tribunal, would they say that people dismissed under that redundancy situation, it was unfair? I'm not saying yes or no on that because we don't have clear enough guidance. I'm saying on that is maybe, and that's something to consider as employers. And there are some maybes at the moment. There are some maybes in all of these questions that are getting asked at the moment, because we don't know how this guidance is going to evolve. There has been further clarification on points. There has been further guidance, and as we go through that, we're changing our advice. We're changing what we talk to clients about, and that's always going to evolve as this goes through. And as someone who is at the forefront of this, of working with small businesses and advising small businesses on how to do this, the questions that they're coming with are changing. And the questions that they're moving towards now are, well, all this was great, where we're up to, we think we're okay with that. But wow, we've got some big stuff coming up. We've got some big questions that are happening, some big things that are happening next. And what do we do with those things? And that's where we're at the moment. And that's where everybody needs to be thinking as businesses. Get planning, get ready now for what's going to happen. Because what you don't want to be is in a situation where you're thinking about, well, if I'm going to be bringing back half of my workforce, where are they going to sit? How are they going to get into work? Do they go up in a lift? When are they going to be together? How can I protect everybody? You need to be thinking about those questions as business owners now, today. You need to be getting those plans in place, because by the time the government say, okay, we're going to reduce the people being in lockdown, relaxing the rules, and I think that will happen in a staged basis. That's just my opinion. But if it gets to that period, you want to be ready for that as a business owner. You want to be saying, great, I've already got my plan. I've already got my key guys, my top guys that I want back in work. Here's a list of them. This is where they're going to sit. This is what they're going to do. I'm happy with all of that. And you want to be ready to go with that when that gets back to work. So that's the next key thing, and that's the next thing that all businesses that we're speaking to are asking about now. So I think session's gone really quick. I know there was a lot of questions that I didn't get a chance to get to, but if you get an opportunity to send those over to us, we'll have a look at them. If you send them over, like I said before, at the beginning of the session, you send them over to COVID-19 at cronercommunications.co.uk. Okay, you get those over to us. That'll be great, because when I do this session next week, we'll look at it then and we'll say, okay, here's a lot of questions, because as I saw some that were going through and I was trying to go through them, a lot of them are very similar questions, but some really good specifics to those businesses. That's the advice I want to give here. But if you get them, we can pull them together. We're getting 5 or 6 of the same ones. And I can start the session by saying, okay, these are some of the ones that we got before. We'll go to them straight away. Here are the FAQs from before. We'll go into them straight away. And I'll cover them off. So if you can send them through, that'd be a big help for me, and it'll help me steer exactly what you want advice on, because I'm here to give you whatever advice you want, and I'm trying to give it in practical terms and not really complicated terms to you, really practical terms for your business. So if you want to just pop them in, I can steer the session to how you want it. So thank you for everything. We're here if you need us to give advice, and stay safe.